Hello everyone, my name is Pawan and I welcome you all towards our YouTube channel of Art of Law. So we have started with this amazing and free initiative of teaching you all for the UGC NET का law का paper, especially for international law. Very important subject. And what are the most important repetitive questions again and again is what we'll be discussing for today. Most of the time, generally, if you learn a pair of questions again and again, if you're able to revise it constantly, even though you're not reading very in a very long length and breadth of that entire book, at least if you're able to revise the PYQs or the important question, that will be more than enough. So from our Art of Law sides, our initiative is to make you to teach law, especially for UGC NET, as well as in a very simplified manner, so that you'll be able to clear this exam at a very first initiative without spending anything, completely free. Yeah, आपको free है, and this is our initiative to support you to reach out towards of your dream profession. Especially, I wish that you all get JRF also. So on that basis, we'll be starting for today. And also have a small request before I start. Make sure that you can also join our WhatsApp groups, and by joining, we can also share across materials and all for your reference and for your preparation too. Now, keeping that in the mind, let's get started. In which case, it was held that a person who is not a citizen of any state will be called stateless. So, in which case was it held that a person who is not a citizen of any state will be called stateless? The answer is it option A, asylum case, option B, Naughty Bohem case, option C, Barcelona traction case, option D is about US versus the Equino case. The answer is Naughty Bohem case. Okay, so in which case it was held that a person is not a citizen of any state will be called the stateless. That means that if I am not a citizen of any particular state, if I don't belong to any particular state, then I'll be called as what? I'll be called as stateless. And in which case they decided, it was decided in the case of Naughty Bohem case. So explored the principles of nationality and address the concept of statelessness. So it's a very important thing. So you should be knowing where they mention about statelessness and where they have not mentioned about it. So आपको थोड़ा clarity होना चाहिए. You have to by heart such kind of questions. Now, second question is about which of the following statement is not correct. So four options are given. According to Article 16 of UDHR, everyone has the right to seek and enjoy in other countries asylum from persecution. Has the right, which of the statement is not correct. Read the questions carefully. Many of the times why students make mistake is about because they don't read the questions properly. That's the biggest of a mistake. So according to the Article 16 of the UDHR, everyone has the right to seek and enjoy in other countries asylum from persecution. Option B is about in 1967, the United Nations Declaration on Territorial Asylum was unanimous. The 1951 entered into force on 24th April 1956. The fourth option is about the asylum case Colombia versus Peru at the International Court of Justice explained the distinction between the territorial asylum and the diplomatic asylum. And the correct answer is which one? Which of the following is not correct? So that's the correct thing. So the option is about according to Article 16 of the UDHR, everyone has the right to seek and enjoy other countries asylum from persecution is completely a wrong statement. It is wrong. Why? Because the right to seek asylum is addressed under Article 14. So what you need to do is about just make sure that important articles under UDHR, just write it down in the book, right? Article 14, 16, 10, 15, 20, 25, and all. Just go through it, just badly write it down in your book and constantly revise again and again. So it's going to be easy. For example, if you observe here, 1967, the the United Nations Declaration on Territorial Asylum was unanimous. That was there. That was correct. 1951 entered into force on 24th April 1956. That was correct. The asylum case, Colombia versus Peru, the International Court of Justice explained the distinction between territorial asylum and diplomatic asylum. 3 option B also you have to learn parallel. Okay. Which of the following statements about the de jure recognition is incorrect? Okay. So the first one, okay, which of the following statement is incorrect? Okay, so the answer, I'll just read the explanation first. De jure recognition is not final and can be withdrawn. So this is completely an incorrect statement, whereas others is correct. So now what I want you to understand is about, let's see the other explanation. Okay, the Hegel is one of the chief exponents of the constructive theory of recognition. So learn the important kind of theories of recognition. Theories of recognition, जो भी types है, just write it down in a book and constantly try to revise. The Civil Air Transport Incorporated Company versus Central Air Transport Corporation is a leading case on the air transport. They can ask this. See, if you observe, learn the options parallelly because they can ask you for other kind of bases. Also. They'll give you an option next time. Which case is regarding the air transport? So apply the common logic here. Air transport is there. Here also air transport is there. So you can apply that. Okay. So now next is about recognition as retrospective in effect. That is there. In Luther versus Sagor, it was held that there is a distinction between de facto and de jure recognition for giving effect on the internal acts of recognizing authority. That is important. Okay. Now, fourth question is about which of the following cases are not related to recognition. Which of the following cases are not related to recognition? So the answer is Barcelona traction case and the UST, this one. So neither Barcelona traction case nor US Equon deals with the issue of recognition. So just remember that this is very important thing. So certain kind of questions आपको by heart ही करना चाहिए, but if you try to understand the case and if you're able to do it, that will be much better. If you observe this particular option, we already learned before. It's related to what, air transport. So you need to analyze that and clarify options like that. Okay. Who proposed the view that existing states have a legal duty to recognize any community possessing the characteristics of statehood. So, who proposed the view that existing states have a legal duty to recognize any community possessing the characteristics of statehood? So, it was actually the Lottery Pact. Lottery, I think I'm pronouncing this guy's name correctly. It's Lothar Pact. Okay, Lothar Pact emphasized that recognizing is a legal duty when a state fulfills the requirement of a statehood. So in order to come as a statehood, there are certain kind of category. Okay, they should be having a territory, they should be having a government. And what are the categories? I want you to let me know in the comment box. आपको खुद का homework करना ही होगा. If you don't do your homework and let me know, it's not going to be easy for you. So just let me know what are the five to six categories given for proving a statehood in a particular country. Okay, so that is very much important. Let me know in the chat box. Sixth question is about which of the following is not a source of international law according to Article 38 of ICJ statutes. So the thing is about which of the following is not a source of international law. So international conventions, yes, it is a source of international law. International custom, yes, it is a source of international law. Judicial decisions and teaching of publicists, yes, it is a source of international law. Whereas municipal law, it is not the source of international law. Okay. Article 38 of the ICJ states that the international conventions, international customs, and judicial decisions and teachings of publicists as a source of international law. Municipal law is not recognized. Remember, municipal law is not at all recognized. Now, seventh question, the case defined the term customary international law. So, which case defined the term as customary international law? It was actually in the case of North Sea Continental Shelf case. Very important case. You should be knowing it without fail. Okay. The ICJ in this case clarified that elements of customary international law emphasize the state practice and opinio juris. Guys, I tell you one thing, okay? Make sure that you're having a book and pen or just take a screenshot of Joby questions I'm presenting now and write it down again and again. Constantly try to practice again. You need to do it regularly. If you don't do, trust me, it's going to be very hard for you. Pura preparation is going to be very hard. See, few days hard work, anything in life you want to get achieve, you need to struggle. Every day is little by little hard work. If you're able to do, what's wrong in that? You're developing on a skill itself, right? Nothing is not losing for you, right? So please do give that effort and give your best. That's a very small request I have for you. In which case was it held that individuals can be subjects of international law? Individuals can be subject of international law was recognized in the case of reparation for injurious case. So in which case it was held that individuals can be subjects of international law. All the individuals are what? They are the subjects of international law. That was recognized in the case of reparations for injuries case. The ICJ recognized that individuals and entities other than states can have rights and duties under the international law. Okay. Which principles of international law was established in the trail smelter case? The no harm principle in transboundary environmental law. Which principle of international law was established in the trail smelter case? Remember that in the trail smelter case, what basic important principle you should be knowing if you've learned international law, that is about no harm principle in the transboundary international law. The trail smelter case established that the principle that a state is responsible for preventing environmental harm to other states. So for example, if I am in America, I am in UK, I'm in Canada, I'm not supposed to create environmental harm to other countries. For example, many of these rich countries, in order to clean their particular cities, their waste now they used to go dump in the other countries like Africa to Nigeria to many states. So in the trail smelter case, they clearly said that you're not supposed to harm the what environment in any particular case. So just remember that. Okay. How does the term just cogence refer to? The term just cogence is basically referred to. I'll just go directly to the answer now. The fundamental principles of international law from which no derogation is permitted. The just cogent norms are parliamentary norms of international law, such as prohibition of genocide and slavery. See, the just cogent principle clearly says that if there is any kind of slavery, if there is any kind of genocide, then it is completely prohibitory action. That's it. It's very clearly it's completely prohibitory action. And it is completely derogatory in nature. The fundamental principles of international law from which no derogation, and also for countries which does genocide or slavery, you can actually conduct a war also for it. So remember that. So, and it is very simple thing. You should be knowing the just cogence ka principle very well. Okay. 11th question, which of the following cases establish the principle of effective control in recognizing statehood? So is it the island of Palms case or case concerning Easy Timor case, Nicaragua versus United States, or Western Sahara advisory opinion? The answer is island of Palmas case. The island of Palmas case emphasized that effective control is essential in asserting the sovereign over a territory. So the case name is what? The island of Palms case is the correct answer. So in this case, what happened? The principle of effective control in recognizing. So the important concept of effective control in recognizing the statehood was recognized in this particular case. In which case was the concept of sovereign immunity revisited? The sovereign immunity was revisited in the case of jurisdictional immunities of state. Germany was Italy. Okay. The ICJ clarified that the principle that states are immune from jurisdiction of other states courts unless immunity is waived off. So remember that very important concept, in which case the concept of sovereign immunity was revisited. That means they gave an emphasis on sovereign immunity. A country has certain kind of immunities, right? Sovereign immunity was referred back in the case of jurisdictional immunity of the state. Germany versus Italy case. Okay, here in this particular case, International Court of Justice said that the principle states that are immune from jurisdiction of other states court unless immunity is waived off. See, for example, if a king from Dubai come to India and he commits an offense, just imagine he commits a rape or something. Do you think that he'll be charged in Indian courts? No. There is actually he's actually waived off from such kind of he's actually waived off from any kind of punishment. He'll be charged from his respective country. For example, if there's a diplomat from an America in his embassy, he commits a particular offense. Will he be charged in our country? No. He'll be charged in his respective country. So remember that. So in order to protect this diplomatic immunity, they provide this sovereign immunity also. Okay. 13th question, which case dealt with the principle of non-refoulement in international refugee law? So the principle of non-refoulement in international law was given in the case of Harish Jamma versus the Italy case. Very important, please to learn it. Okay. The European Court of Human Rights ruled that the principle of non-refoulement prohibits the return of individuals to countries where they face the persecution. That means that if I am facing for example, if I'm in a country and I'm basically what facing some kind of persecution, that means that their persecution happens because of various reasons, because if it could be, there is a violence, there is a very big war happening in that particular country and they're throwing you out because of war, or it could be about religion aspect, or it could be about any aspect which it is against the human values, to be honest. So this European Court of Human Rights have ruled that the principle of non-refoulement prohibits the return of individual countries where they face persecution. So it basically, see, this is a very good rule. Okay, it says that if you are facing, so you are coming out of country A to country B by because you're facing persecution, because there is war, violence, persecution because of religion, or it goes because ethnic groups are basically suffering a lot. Now, what happens if they come into a particular country? Now, you should not push them back to go to that same country until the persecution gets over. Why? Because again, if they go back, what will happen? There will be mass sacrifice being happening. Okay. The How does the Pacta sunt servanda mean in international law? Very important. I'll just go directly to the answer. The treaties are binding and must be honored in good faith. So any treaty, if it is being signed by India, America, Australia, everyone should basically be following it in good faith. That is very much important. So treaties are binding and must be honored in good faith. 15th question is about in which case was the principle of uti possidetis juris, respect of pre-existing borders, affirmed. It was in the case of frontier dispute case, Burkina Faso versus the Mali case. The ICJ reaffirmed the principle that newly independent states must respect the colonial boundaries to avoid disputes. So very important concept, yeah. I hope this answer itself, what I explained you, it's like very clear thing. So in this, International Court of Justice has very clearly said that all the Joby new independent states have come, they have to respect the colonial boundaries to avoid any kind of disputes, because they will tell that this land or this boundary belonged to us from a very long period of time. In order to overcome that particular dispute, you need to respect it. So that was also been said in the case of frontier dispute case. So this much are the 15 important questions. It's a quick rapid revision of your international law. Make sure you're revising these questions again and again. Join our WhatsApp group. We'll be happy to connect you, help you again and again. Take care. Goodbye. And this is me, Pavan, signing off. Wish you all the best and good luck.